All right.
Good. Welcome. We are going to be discussing Unit 5, Question 1. Before we get started, judges will introduce ourselves. My name is Richard Leiter. I'm the director of the Law Library and professor at the University of Nebraska College of Law here in Lincoln, Nebraska. This is my first national competition to judge. I've been involved on the state level judging for about 15 years. Candida? I'm sorry.
Sorry. Kurt, let me.
Kurt, you want to take?
Yeah, please. Good morning. I'm Lieutenant Colonel Kurt Mavis. I'm an attorney with the United States Air Force, practicing for about 12 years, a previous alum of this program, and I'm currently teaching at the United States Air Force Academy. Candida, are we better? Over to you.
Yeah, much better. Thank you. Hi, my name is Candida Steele, and I'm retired as a judge on the U.S. Civilian Board of Contract Appeals. I handled federal government contract disputes around the country, and I've been judging with the program for 20 years, and I'm thrilled to see you all.
The team, this is New York, correct? Good. You want to introduce yourselves?
Hi, I'm Jennifer Sachs.
Hi, I'm Zarina Rahimi.
Hi, my name is Ian Huang.
My name is Jason Nguyen, and we are Unit 5, and our teacher is Mr. Pickman.
Hello.
Very good. Nice to meet
Where
you.
are you in New York?
What was that?
What school are you? Where are you in New York?
Half Howell Hills East.
Where?
Half Howell High School East.
Welcome.
It's out on Long Island.
Yeah, I grew up in New York, so I just was
Awesome.
eager to know.
Great.
Sorry to interrupt, Richard.
All right. We are going to talk about question 1. As a result of the decision in Wisconsin v. Yoder, is that any parent or guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with the result of this decision? Why or why not? What words, if any, are found in the US Constitution or in state constitutions that protect the right to an education? And how have courts balanced religious beliefs with other rights?
George Washington said, "While we are contending for our own liberty, we should be very cautious not to violate the conscience of others." In accordance with this, Justice O'Connor states that perhaps the right of a parent to control the upbringing of their children is the oldest of the fundamental liberty interests recognized by this court, as was ruled in Meyer v. Nebraska. The decision of Wisconsin v. Yoder further confirmed O'Connor's statement regarding deference to a child's parents. As stated in Justice Stewart's concurring opinion, no facts in the record suggest that the children's religious beliefs were at variance with the beliefs of their parents.
As noted by Justice White, having the children miss the last 2 years of public schooling is not so problematic that the respondent's religious beliefs should be subordinate to state's interest. Despite the children's implied right to education in the 9th Amendment, we agree with the outcome of Wisconsin v. Yoder, as the decision follows the fundamental rights of freedom of religion. The founding fathers understood the importance of education to democracy, but education is not mentioned in the U.S. Constitution. While the right to education may not be an enumerated right in the Constitution, the 9th Amendment states that people retain rights absent specific enumeration, therefore giving the right to education justification.
But may also be protected under the Equal Protection Clause of the 14th Amendment. The 10th Amendment, however, gives the states the power to decide whether or not to include the right to education in their constitutions. In fact, the Supreme Court ruled in San Antonio Independent School District v. Rodriguez that there is no fundamental right to education in the Constitution, so the burden for providing a system of public education falls to the states, who use different language.
For example, Colorado, Texas, and New Jersey describe public schools as thorough and efficient, while Arizona, South Dakota, and Oregon uses the words general and uniform instead. This had an implication in the case of Campbell County School District v. State. However, unlike education, religion is stated explicitly in both the U.S. Constitution through the Bill of Rights, as well as many state constitutions, and was incorporated in the case of Cantwell v. Connecticut. Freedom of religion is specifically applicable to educational institutions, since the case of Everson v. Board of Education incorporated the Establishment Clause.
We conclude in the eyes of the court that the freedom of religion is superior to the right to education. This is supported in cases such as Zorak v. Clausen and Minersville v. Gabaitis, where the Supreme Court favored religion over education. In the case of Edwards v. Aguiar, the teaching of intelligent design, the idea that God set the universe in motion and that science can ascertain this as a fact, was ruled unconstitutional. Thus, the right to education exists so long as it does not infringe upon the freedom of religion or any other higher right.
One of the challenges the US government faces is the balancing of freedom of religion with other rights. The court has simplified the process by incorporating the Establishment Clause and the Free Exercise Clause into the states. Professor W. M. McConnell states the Establishment Clause was designed to avoid undue concentration of power, specifically to prevent the federal government, and after the 14th Amendment, all governments from assuming the power to control the religious life of the American people. This is seen in the case of Engel v. Vitale, in which the Supreme Court deemed it unconstitutional for state officials to compose an official school prayer to encourage recitation in public schools.
Religious rights are often argued in cases of discrimination, which can be countered with the 14th Amendment, which bans all discriminatory legislation based on any classifications that gave some classes of citizens greater rights, including religion. Discrimination has also been lessened with the No Religious Test Clause, which guarantees that individuals will not be barred from holding office based on their religion, thereby shifting the balance against religion. In the case of McDaniel v. Patty, the courts unanimously ruled that the state law violated both the First and 14th Amendments, thus balancing the implied right to work in the Ninth Amendment with religious freedom. As James Madison stated, the religion of every man must be left to the conviction of every conscience of every man, and it is the right of every man to exercise it as these may dictate. Thank you. We are now ready for questioning.
Thank you. Thank you very much. Well, let me get this question started. I really enjoyed the depth with which you've explored this issue, and let's take it for granted that the right of religion is a dominant right compared to right of education. How do you balance the parent's right to freedom of religion against the child's? In this case, should the child's religious beliefs be balanced against the parents when deciding when to cease their education?
I think in this case, we have to look at the fact that these children are in fact minors, so you do defer to the parents there. And it was in the case of Meyer v. Nebraska, which we did cite in our speech, we did rule that that right was the most important. However, what I think is the most important to look at in Wisconsin v. Yoder specifically is that you can still go back and attend a public school once you do turn 18. So if that is something that that child wants to do, then I would personally encourage them to do so. But until they are not a minor anymore, we would defer to their parents, I would think.
As a minor, the safety and the well-being of the student should be taken into account. In situations such as Prince v. Massachusetts, the court deemed that if the safety or the well-being of this child is at jeopardy, the parent may be held responsible and persecuted. So in this circumstance, if the education is deemed important for the well-being of the child, the parent should.
I think what my colleague Jason is trying to say is, if education is deemed like a government interest, it's a right that has the interest of all the children, then it should be allowed for all the minors to attend education. An example with that would be vaccinations. Some states allow, some states don't. New York, for example, our state does not allow religious exemption from vaccinations, while New Jersey does. So in this case, the New York government found that vaccinations was a government interest, and it trumps religion.
I'm actually gonna go ahead and disagree with my colleague Jennifer and partially agree with my colleagues Jason and Ian. And this is because I believe that parents do have the right to of their children as they are minors. However, in the case that the parent is deemed unfit to make decisions for their children, I like to bring up the case Troxel v. Granville. And in this case, this was a turning point for the Supreme Court where the Supreme Court started to side more with the children's decision. And this is because as the children do get older, they start to be able to make their own decisions. And this could be even seen when a children goes into school. They are minors, they still do hold some rights. It doesn't mean like when you turn 18, that doesn't mean when you access all of your rights. You start to slowly access them as you go older. And it's because you gain more of a decision-making ability.
What kind of scrutiny do you think should be used in these kinds of cases? Minimum, strict, or?
In these cases, I do believe it should be the strict scrutiny test, especially when you look at vaccinations, like my colleague Ian brought up. I think the reason why I think it's so contested and why that does vary from state to state is because you are using that very strict scrutiny. And so what I think happens there, it ends up, the ruling of those state courts does end up dependent on the values of that state.
And even going on to what my colleague Jennifer said, even vaccination, even privacy, the right to privacy, which is not really implicated in the Constitution, but it's implemented sort of in the 9th Amendment. The schools can search a student's locker, student's backpack, if it's deemed that the student was may have some suspicion of contraband or is deemed a threat to the school.
Yeah, and I also like to agree with my colleague Jennifer and Ian. And this is because I think that the state should have the right to, based on how the state rules, then I believe that it is up to the state to decide what type of scrutiny. And I like to bring up education. Education is incorporated into the states, and each separate state has its own separate ruling. As we said in our speech, different states in their constitution have different wording. And with that comes different rulings.
But isn't that part of the problem? Now we're talking about, it depends on literally within 5 miles of where you live is going to have a different impact on what your fundamental rights are. So is this a decision that needs to be pulled up to the federal level to clean it out across the board?
I do think that it is possible that at some point this right may be pulled up to the federal level. However, I do think that that's exactly why the right to education isn't explicitly mentioned in our Constitution. It is seen as implied in the 9th Amendment, and it has been defended using the 14th Amendment. However, unlike the right to freedom of religion, which is explicitly stated in our Constitution, education isn't as high of a right.
But why not? Shouldn't it be? I mean, we're talking about these huge differences in how a state is going to handle your education.
Honestly, I don't think that it should be as high of a right as religion, since it has been a power that has been historically left up to the states. And I do think that that was with good reason, because I think that a standardized education across the board would end up the government would end up having too much power. Sorry, the federal government, that is, would end up having too much power over the states. I do think that we've left that up to the states for good reason.
Yeah, and I also like to bring up the fact that people do hold power in the government. They can, the reason why the government exists is because of people. And if they want to make changes in the government, like on education, then they can help make those changes by calling their government officials or and when there is another constitutional convention, they can help change some of those things that they might deem unfit.
What about No Child Left Behind, though? I mean, the federal government does seem to want to get its finger in the pie on education and national standards and things. What do you think of that?
I think that that's exactly why we need to prevent education from being pulled completely to the federal level, precisely because we already see the federal government trying to overreach their power. And I think that that is quite a slippery slope.
While I agree with my colleagues, may I continue?
Yes.
While
Please.
I agree with my colleagues Jen and Zarina, in certain cases such as Epperson v. Arkansas and Edwards v. Algard, it's shown that education has trumped religion once or twice, such as evolution, and how states banning the teaching of evolution is unconstitutional. So in that circumstance, education was brought to the Supreme Court, the federal level, and was deemed more important than religion.
Great.
Okay, thank you very much.
Great point.
Good job. And now it's our opportunity to give you some feedback. Candida, do you want to take the lead here?
Sure. I thought that was a lovely job, and I especially appreciated your extra sentence there at the end about education trumping religion sometimes. That was an excellent point. I think you did a really wonderful job. You obviously all have studied very hard and appreciate what you've been studying, and I hope you may want to be farmers or in the Navy or something, but if not, if you're interested at all in what you've just been doing, I hope it will inspire you to not only be great citizens, but perhaps represent us down the road. We certainly need people in government, local, state, and federal, who know what they're doing and who understand what government is supposed to be. And you've clearly demonstrated that you have a very good understanding of what the government can and should try and accomplish. So thank you. It's been a pleasure listening to you, and I think you did a wonderful job.
Yeah, I do echo that. Coming out of the gate with GW, always a strong move. Yeah, like hearing about George Washington, because it's not expected necessarily in this type of question. But I really like you setting the stage there. Your breadth, your depth was great. My one caution to you is you threw a lot of cases out there that I don't have necessarily context on. So if you can just add just that little bit of context to make sure that I understand why you're using that as authority or why you're using that as precedent, like you did in your Q&A. You did a great job in your Q&A, like Jason wrapped it up perfectly when he was talking about why he brought in his final case. That helped me give the context of why you're making that argument, because you had a ton of good stuff in there, and it was hard for me to keep up. So amazing job, well done, thank you.
And I just echo my colleagues' comments. I thought this was an outstanding presentation. You demonstrated a good understanding of the subject matter. I was really impressed with the number of cases that you comfortably brought into your arguments. But as Kurt said, a little context would be helpful, but they were well inserted into the conversation. So you did, it was very successful. It was very good. Excellent job. And very proud that there are high school students out there as conversant in the Constitution as you are. I feel very good about the future.
Certainly did better than my law school class would have done.
Oh my gosh, yes. Thank you. Good job.
Thank you for judging us.
Our pleasure.
Oh yeah.